Hello friends, welcome back to my channel. Today I am going to discuss about proposal under Indian Contract Act 1872. So let's start. The term proposal has been defined in section 2A of the Indian Contract Act. Section 2A goes like this. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. So, as per the definition, the willingness to do or to abstain from doing something must be made with a view to obtaining the assent of the other party. So, let me explain this with the help of an example. A is willing to sell a radio set to B. Now, A's willingness to sell his radio set to B for rupees 500 if B accepts to purchase the same amounts to proposal. So, if A shows his willingness to sell his radio set to B, if B accepts to purchase that particular radio set, that will amount to proposal. But if A only makes a general statement that I want to sell my radio set to B, then that won't amount to proposal because that has been made without any intention to obtaining the assent of B. So, for a proposal, it is very much necessary that the willingness to do or the willingness to abstain from doing something must be made with a view to obtaining the assent of the other party. I am repeating the example once again. A wants to sell his radio set to B. Now, if A says, I want to sell my radio set to B for rupees 500 if B accepts to purchase the same. So, this will amount to proposal because here A has made a proposal with a view to obtaining the assent of the B. So, this will amount to proposal. But if A just makes a mere statement that I want to sell my radio set to B for rupees 500, but this will not be a proposal because here the statement is made without any intention to obtain the assent of B. So, for a proposal, the willingness to do or to abstain from doing something must be made with a view to obtaining the assent of the other party. One thing to be noted is that the term proposal used under the Indian Contract Act is synonymous to the word offer or the term offer used under the English law. Now, difference between offer and invitation to offer. So, let's understand this difference with the help of an example. For example, there is a bookseller and that bookseller sends catalog of books indicating the prices of various books to many persons. Now, this catalog which the bookseller sends to many persons is not an offer. This is just an invitation to offer. Now, by reading the catalog, if any person is interested in purchasing the book mentioned in that particular catalog, then that very person may make an offer and the person circulating the catalog has a discretion to accept the offer or not to accept the offer. Similarly, inviting persons to an auction where goods to be auctioned are displayed is not an offer for the sale of goods. This is just an invitation to offer. Another example is advertising calling for tenders. The advertising calling for tenders is not a proposal or offer. This is just an invitation to offer. It is an invitation to the contractors for making an offer. The submission of the tender is in the nature of an offer and it will result in a contract only when the tender is accepted. So, these were few examples which shows the difference between offer and invitation to offer under the Indian Contract Act. Now, when we are talking about offer, then there may be a question whether the quotation of the price may be held to be an offer or not. So, there is a very important case in this regard, that is Harvey versus Facey. So, in this case, the defendants, they were the owners of a plot of land known as Bumper Hall Pen. Now, the plaintiffs, being interested in purchasing the same, sent a telegram to the defendants, will you sell us Bumper Hall Pen? Telegraph lowest cash price. The defendants in reply telegraphed, lowest price for Bumper Hall Pen is this. Now, The plaintiff sent another telegram to the defendant saying, "We agree to buy bumper hole pen for rupees this much," as quoted by the defendants. "Please send us your title deeds." Now the defendant refused to sell the land. The plaintiff aggrieved by the same. The plaintiffs filed a suit, and they contended that the second telegram from the defendants quoting the lowest price was an offer, and the same had been accepted by the plaintiffs, and the contract was complete. Now, the defendant contended that quoting the price was not an offer which could be accepted. The court in this case held that the first telegram had asked two questions, one regarding willingness to sell and the other regarding the lowest price. The first telegram was sent by the plaintiffs. In reply, the defendant, they just mentioned the lowest price but they did not show their willingness to sell the property. Again, the third telegram from the plaintiff saying, "We agree to buy," was only an offer and not the acceptance of the offer. So the court held that since this offer had not been accepted, there was no binding contract between the parties. So, as per the case Harvey versus Facey, quotation of the price was not an offer. The court held that mere quotation of the price cannot be held to be an offer. Now, coming to communication of the offer. Section 2A of the Indian Contract Act explains that a person is said to make a proposal when he signifies to another his willingness to do or to abstain from doing something. Now, as per the definition of the proposal under Section 2A, we can see that the requirement that the willingness to make a proposal should be signified. So, the requirement is that the willingness to make a proposal should be signified. The term signify here means to make known, that is to convey. So, it is very much important that the offer must be conveyed, the offer must be communicated to the another person, that is the offeree. When the offerer wants to offer something to the offeree, that very offer must be communicated to the offeree. So, communication of the offer or the proposal is the requirement. Now, how an offer is communicated? As per Section 3 of the Indian Contract Act, an offer may be communicated by the offerer by any act or omission by which the offerer intends to communicate such offer to the offeree or which has the effect of communicating the offer to the offeree. So, the offer may be communicated by an act or by omission by which the offerer either intends to communicate such offer to the offeree or such act or omission itself has the effect of communicating the offer to the offeree. An offer can be made by words or by writing or by conducting in a manner which has the effect of communicating the offer to the offeree. It is to be noted that an offer may be either an express offer or an implied offer. Now, express offer means which is made by some positive act on the part of the offerer to the offeree. An implied offer means which is inferred from the conduct of the offerer. So, express offer and implied offers, this is mentioned under Section 9 of the Indian Contract Act. As per Section 9, insofar as the proposal or acceptance of any promise is made in words, the promise is said to be express. Insofar as proposal or acceptance is made otherwise than in words, the proposal is said to be implied. So, an offer made otherwise than in words is said to be an implied offer, and it is an offer that is inferred from the conduct of the party. An offer would be an express offer when it is made by words or by writing. So, this is all about communication of offer and express and implied offers. Another very important aspect is completion of the communication of offer. When is the communication of offer is completed? As per Section 4 of the Indian Contract Act, the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. Thus, As per section 4, the communication of the offer or the proposal is complete when it comes to the knowledge of the offeree. Now, it can be said that an offer cannot be accepted unless it has been brought to the knowledge of the person to whom it is made, that is the offeree. To put it in otherwise, A cannot be said to make an offer to B unless A brings the offer to the knowledge of B. Here A is the offerer and B is the offeree. So, if A is making a proposal, then A cannot be said to make an offer or a proposal to B unless A brings it to the knowledge of the offeree, that is B here. So, the communication of a proposal or an offer is completed when it comes to the knowledge of the offeree, that is the person to whom it is made. So, this is all about offer, communication of offer and the completion of the communication of offer under the Indian Contract Act 1872. Thank you for listening, and in my next video, I will be discussing about acceptance under the Indian Contract Act. Thank you for listening, and if you like the content of my videos, kindly subscribe to my channel and please like and share my videos. Thank you.